Okay. All right, welcome to our talent view training for mock trial this year. Thank you all for joining us. We have 3 speakers for you today. So first, we want to give a little speech about ethics of competition. And this goes across the board with sports and mock trial and just all sorts of genres. So we have a guest speaker with us today who does Taekwondo training, and this is a etiquette lesson that she gives her students. So if you all can help me welcome Jenna Burks.
Of course, we have to break it down. What is an art? An art relates to the Latin word ars, meaning art, which is skill or craft. To be trained in an art, such as the martial arts or culinary arts, for example, it takes more than just partial commitment to its studies. It requires time committed to increase skill. It's safe to say that if you put yourself in a position of learning an art, you will be challenged to grow and learn in multiple ways because it becomes all-encompassing. So what is debate? Debate is a formal discussion on a particular topic in a public meeting or legislative assembly in which opposing arguments are put forward. And I asked Ms. Ussery, what are the key virtues of logic that are taught at CC? And she explained, the topic needs at least 2 components to make it a logical statement resulting in a solid argument. These 2 components are validity and truth, and I'm sure you have experienced those words before. So validity being in line with the laws of nature, science, as well as being structured in the correct manner. Truth being defined with the laws of God and human nature. And these are the key components of a logical argument. Without one, you're left with a frail statement that cannot support itself. You must have both. So before I move on to the next portion, I just want to say I am basing a lot of my information and supporting it by scripture. Because if you don't know God, it may seem a little new. It might look weird to you. So if that's something you want to discuss later, I'd be happy to sit down and talk with you about that. Okay, so how do these 2 relate though? The martial arts. I'm giving it a broad spectrum. We do train Taekwondo, which is a single art, but it can pertain to multiple arts. So you might think they have no connection at all, but what I'd like to present is a positive position of affirmative. Yes, they do. So if we choose a side, debate or arts, you might think these are opposing positions, but why must they be? What you first might consider is a normal moral grounding in your stand on either topic. If we're called as Christians to see the world in a biblical worldview, then it gives us a basis of information to work from. In martial arts, we have 3 pillars and 6 tenets that we practice under. The 3 pillars state knowledge in the mind, honesty in the heart, and strength in the body. The foundation of a good martial artist is built on these 3 pillars. Keeping in line with a biblical worldview, we can easily see that these pillars are a parallel to the spirit of an individual. So let's talk about debate in the pillars. Knowledge in the mind. Let's start there. As a debater, the student of logic, you will try and increase your knowledge on a topic to be able to give reasoning to why you support it. And your knowledge should be factual. In martial arts, we increase our knowledge on the arts and techniques so that we can be able to support our training and validate our methods. Honesty in the heart. Well, in debate, it's a choice. You don't have to believe what you're debating is moral or the correct thing. But it's well known that excuses are quick killers to any argument. An excuse isn't logical and would prove for a poor debate. In martial arts, honesty is the key point in our existence. If we are not honest in our hearts, we'll not be able to apply our tenets effectively, and the excuses start to swell up, taking precedent over all of our pillars, resulting in out of balance growth. Thirdly, we have strength in the body. It's kind of easy to see that you would want strength in your body, training in an art like martial arts, because of the structure of how the art is built for physical defense and the ability to maintain a balanced mind, soul, and spirit. In debate, if we choose a biblical worldview, we're asked to submit our members into subjection. The Bible says, answer not a fool to his folly, in Proverbs 26:4. If you're showing a physical attitude of superiority or body language that's contrary to your position, you're showing a weakness in the body of your debate itself. So keep that in mind because we're going to bring that back up in the tenets. Breaking down the pillars is only the start. Believe me, I didn't want to share this for a while because it was kind of hard to explain the arts to people if you've never done it. It's kind of like explaining to someone what ice cream is if you've never tasted it. It's kind of a hard situation to be in. But if we break down these tenets, I think you're going to agree that some of this really will relate to you in your debate situation. So first we have, and hopefully everyone can see this, courtesy. And I have a definition and a scripture to support it, as I said before, on every one. Courtesy is intentionally placing value on those around me. Philippians 2:3. Let nothing be done through strife or vainglory, but in lowliness of mind, let each esteem other better than themselves. A word you might have heard more commonly used is humility. I want you to just think about the 2 differences in those words real quick, because courtesy and humility, although they are similar, they're not the same thing. So courtesy actually requires you to intentionally raise someone up and lower yourself. With humility, we can just lower ourselves. So there's a difference in the positions of the action there. So keep that in mind. Secondly, we have integrity. Integrity is a personal commitment to morality and principle. Proverbs 4:25 and 26. Let your eyes look right on, and let thine eyelids look straight before thee. Ponder the path of thy feet, and let thy ways be established. Yeah, I see that. I left it there. I don't care. I'm not perfect. My husband would be like, you have to redo the whole thing. No, that's not me. Okay, perseverance. It's pushing through all adversities and eliminating excuses. In Galatians 6:9, and you've probably heard this before, let us not grow weary in well doing, for in due season we shall reap if we faint not. This is a big one that we all know and have heard, but I do have a point to make about self-control. The definition that we have is remaining in full command of my being despite physical or emotional impulse. And Proverbs 16:32 says, he that is slow to anger is better than the mighty, and he that ruleth his spirit than he that taketh a city. So I want to pause on this one. I mentioned I would come to it. Self-control. A lot of times we look at self-control and we say it is a refraining from doing something. But self-control is actually likened to a two-sided coin. So it's not just one aspect, it's two. So when you're looking at self-control, I want you to think about you are refraining from something to have self-control, but you also have to do something. It can be an action to have self-control. So a lot of times we just think, oh, self-control is not eating that cookie or not saying those words. In debate, I might want to refrain from saying the word never or something like that because that's accusing them of something they've done. But it also is an action too. So it might be self-control would be to set your alarm and get up when your alarm goes off, right? So doing something requires self-control as well. So just giving a little bit deeper content to self-control as we move forward. Okay, indomitable spirit is one that cannot be defeated despite physical or emotional impulse. And there's only 6 tenets, so if you're counting, we're almost done. 2 Timothy 1:7 says, for God has not given us the spirit of fear, but of power and of love and of a sound mind. We could spend a lot of time on the verses. I'm just going to give them to you as support. Okay, victory is the last tenet that we recite. And it's a commitment to never-ending growth through a personal application of, and we say the tenets of Taekwondo, you could replace that with logic and debate, validity and truth, whatever you want, your own name. Philippians 4:12 through 13 says, I know both how to be abased and I know how to abound. Everywhere and in all things I am instructed both to be full and to be hungry, both to abound and to suffer need. And everyone knows this probably. I can do all things through Christ who strengtheneth me. Amen. So I'm going to pause on this scripture though because it does have a lot of meaning, and if you unpack it, it can take a while. But I just want to note that God is asking us, and if you are a Christian and if you know him, he's actually telling you and instructing you to be both full and hungry. And you're like, what does that mean? How can I be both things? How can I be humble and proud, right? Well, he's telling you to not just do one or the other, but to execute both at your best ability through him. So you can be seeking after knowledge and still be humble enough to learn, right? Mm-hmm. You can have knowledge and still be humble enough to share. So it's executing both at the same time that he's asking us to do. So even without your biblical worldview, a viewpoint, how do these tenets align with debate process? I will open up for discussion in a minute, but often I've noticed that you guys build something called an Annie chart. Is that right? Mm-hmm. You heard that before? Okay, good. I'm not wrong on that. So it helps you to gain content for your stance on an argument or issue. And I guess you could attribute the 3 pillars that we talked about as your Annie chart, and the tenets are used in your presentation and execution for physical, mental, and emotional support. So if you just took 2 tenets, for instance, and related them to your validity and truth, I just take an Annie chart example here and put the pillars: knowledge in the mind, honesty of heart, and strength in the body. And then I put the 6 tenets here as support to pull from. So if you wanted to fill out your chart, and as you're going through the process, you're looking for this to be your execution, and this is your attribute. So if you just took 2 of these, for instance, in my argument, I'm going to talk about whatever you choose. And does it have courtesy? And am I going to have perseverance in this? Am I using integrity and self-control? I would say start with 2. We don't ask anyone in the arts to be able to have these attributes at all times. That's not what it's about. The 6 tenets are there to strive for. You're striving to try to become these things and to practice these things, and that's how you gain victory. You can really just take any aspect of these tenets and put them up against what your argument is or what your position is in your debate and see if they're going to contradict each other. You're in a position in the middle of your argument, if you will, and your body language is saying something different than the words coming out of your mouth. That's the double-sided coin of the self-control that you're missing, okay? So be mindful of that. What do you want to say? I just put a little... That's our website if you want more information or want to reach me. What I want to challenge you guys to do is to think about these character traits and how they would relate to your, like she said, ethics, right? How you would use them daily, but also how you would use them in your process of building a good argument and building a good reputation as you're doing that. So, body language, posture, your speaking, the words you use, your intent, is it courteous? All of these things matter and they come across loud and clear if someone wants to be taking out them. If you're on a stand against someone and someone else is being humble and you're not, it's going to show. Please come by and see me and ask any questions you have.
I'm Holly Foreman. I am the Director of Challenge B in Brains and Foresight, and I'd like to introduce you to Mrs. Jerry. She will pronounce the last name.
Thank you for having me. My name is Carrie Sarton, and I'll tell you a little bit about myself. I'm one of the attorneys who will be speaking with you today. So if I understand correctly, you're going to hear from two different types of attorneys, and I think that might be one of the best things you can take home today. There are lots of different ways to be an attorney, just like there are lots of different ways to be a doctor. There are lots of different ways to be a teacher. There are lots of different ways to do just about any profession. So the way I practice law is I'm a technology transactions attorney. So I work for a Fortune 500 company that makes software. I don't even know how many types of software we make. I think we have over 1,000 products. But I help the company buy and sell software that gets loaded into programs either in our operating environment or in the operating environment of someone else. I also lead our intellectual property practice. So patents, copyright, trademark, trade secret, all that kind of stuff is in my world. So we are talking about mock trial today, and that's where you are pretending to go to court, but it is actually my job to keep my company out of court. So if we go to court, then I probably messed up, or someone on my team probably messed up. So I have to have an interesting interaction with the principles of evidence and what goes on in a courtroom, because I have to know what would happen if we were there. So I have to play it out like theater in my mind to make sure that what I do when I'm helping write or negotiate a contract is that it is so clear that we don't need to go to court. So the reason people need to go to court is when something's not clear. So there are two different types of areas of law when you're looking at being in a courtroom. So you have civil law. So I'm practicing in the civil law area. If I mess up, it's only money. Nobody goes to jail. If I write a bad contract, there's no way I go to jail. There's no way in my company anybody goes to jail. So that's kind of a relief for me. The stakes are a little lower. That's civil law. The burdens of proof in civil law are lower. And I think your next speaker will focus a little more on burdens of proof, but those really matter for what you're doing. And then the second area of law, the world you are living in this mock trial, is criminal law. So the burdens of proof are way higher. Why would that be? Why would we want to be more certain in a criminal case than we might want to be in a civil case? Does anybody have an idea? Yeah?
They go to jail.
They go to jail! Or they pay like mega money individually, not a corporation. So we have this thing in the United States of America that's called innocent until proven guilty. So that means, if you think about it, the presumption is that the defendant is innocent. And the prosecution has to go up this massive mountain to prove that they are actually guilty. So in my area of law, in civil law, we come in on evens playing fields. The one side is considered even with the other before we start. Maybe we did, maybe we didn't. We're all going to find out together. You do not come in on an even playing field in a criminal case. You come in like this, and this, or depending on which way you're looking at the courtroom, we'll make this one the prosecution. They have to climb this hill to even get up here to where the defendant is. So that's an important thing to think about. You all are not coming in on an even playing field. There's a lot more work to do on the prosecution side. You got a lot more to prove. You have to come all the way above that mountain and hit that burden of proof. So you are doing mock trial. Your colleagues before you have done mock trial. They do mock trial in the public schools. They do mock trial in other private schools. So this is kind of like a thing that educators really think is important. So if you are guessing, why do you think mock trial has been incorporated into your curriculum for your 8th grade year? What are some guesses? What are some life skills that we might be approaching here? Hand, I like you. Okay, what's your answer?
Just in case.
Yeah, just in case, right? Just in case you're a prosecutor, right? Just in case that, yes. Yeah, that's a huge part of it. The ability to be an advocate. Yes, sir.
The ability to debate with someone and prove your point.
Stand your ground. I like that. What else? What other life skills do we have going on here? Yes, ma'am.
Defend our faith.
Yeah, defend your position, and often the times that is our faith. That's very true. Anything else we've got going on here? Yeah.
Learning more about our judicial system.
Yeah, that's a really big impact on our life. So the last thing that was said is learning about our judicial system. All of those answers are correct, and then some. So we are going to unpack some of those skills today, but I want you to keep that in mind, that even if you think you may never want to be an attorney, even if you think you never want to set foot in a courtroom, these are still really important life skills. The ability to be an advocate, the ability to convince someone of your position, the ability, as our previous speaker said, to have self-control in a really heated environment. These are all really important life skills. So we do want to learn a little bit more about the American justice system. And while it has its flaws, I'm sure we all have sadly seen some of those cases where someone was sent to jail, later evidence is discovered, their name is cleared, they come out, and those things are heartbreaking. That is what we do not want to happen. We do not want the innocent punished for something they did not do. But we take the risk in our judicial system to say you are innocent until you're proven guilty. Other judicial systems have a different default. You are guilty until proven innocent. So if you are accused, aren't you glad you're sitting in the seat of innocent until proven guilty? And as a society, we choose to see the best in others until the unfortunate is absolutely proven. So when we go to court, the reason we are there is to decide. There is decider of fact and decider of law. We'll get to that in just a moment. But we are there to decide as a community, should this person pay the punishment or suffer through the punishment that goes with a crime? So how do we decide? Like, do we just bring in stories about all the bad stuff they've done? How do we decide what needs to be discussed when we're in a courtroom? Have you given that some thought? So we have to show, not that they were a bad person in general, but we have to show specific laws that they have broken, and then we match. We match the punishment to fit the crime, if you've heard that saying. So in your case, and I'm not sure how detailed it gets, but in a real life criminal case, there might be up to 12 or 13 laws that are being reviewed. So you may have heard words like aggravated assault. So an assault is different than an aggravated assault. So the prosecution may accuse them of assault, and they might also accuse them of aggravated assault. Because if we can't hit the standard for aggravated assault, that's hard to say, we might just get assault. It's like a fall down or back up. So I don't know that you all are doing different levels of crimes, but you do have to show, if you're the prosecution, that in fact the law was broken. And if you're on the defense side, what are you trying to show? Yes.
The defendant is not guilty.
They did not break the law. Maybe they did some bad stuff. Maybe their mom's embarrassed by their choices, but they did not break the law. So that's what we're focused on. Did they or did they not break the law? So the very first thing we do in law school is we learn about elements of crimes. And so I'm going to save you the first 2 days if you ever go to law school. The first thing you learn about is battery. So that it has 4 elements, and most crimes do. So in order, you got to think about, there's a big old box here. Before we can check this box that you did in fact break the crime, you have to check every single sub box below that. You have to think about ring the bell or touch the base. Like, anybody play baseball out here? Thank you so much. What happens? You hit the ball out of the ballpark. You start running. We're all cheering wildly. You hit first base. You hit second base, but you get kind of distracted around third. You don't actually touch it, and you run home. Do you score a point?
No,
Why not?
because
You went around the whole ballpark. Why don't you get a point?
You didn't touch all the bases.
You have to hit everyone, or it doesn't count. So, like baseball, in a courtroom, you got to ring every bell. where you got to touch every base, and you have to know what they are before you get there. So let's look at battery, because I'm pretty sure it's not involved in your thing. So the first, you have an act by the defendant. So that's shorthand for defendant. You have intent. You gotta want to. You have to have contact that is harmful or offensive. You don't actually have to write these down, just make four boxes. And then the defendant, or the victim suffers harm. Okay, so let's play around with this a little bit. Let's think about some situations where someone might hit some but not all. Okay, this has to be a conscious act. So why do we say, you think here, that it has to be a conscious act? What if I am having a heart attack and I'm struggling and I'm trying to get my breath and I fall in her lap and I hurt her a whole lot? Was that a conscious act of mine if I'm having a heart attack? No, I'm not in control of my body at that time. So even if this lovely young lady is harmed, we don't have a conscious act and we can't ring that bell. She might suffer harm. She might be very offended that I embarrassed her in front of all of her friends by landing on her lap. But can she take me to court for battery? No, she doesn't. She can't check this box. No matter how many ways she tries to slice it, she doesn't get this one. So intent, same thing is at issue in the example I just gave you. Did I make a conscious choice in my mind and set out to come in contact with her? No. I'm trying to get some air and I'm trying to get to a place of safety, struggling in the middle of my heart attack. So, did I make contact that was harmful or offensive to a reasonable person? Would lambasting on someone's lap be either harmful or offensive? Yeah. So we can check this box. I did actually do that. And did she suffer harm? So let's say I break your nose. I'm so sorry. When I land in her lap, I break her nose. Did she suffer harm?
Yes.
Yeah. So we got 2 checks. But did I commit a battery? No. Because we didn't get all of them. So let's say you're my hypothetical defense attorney, and let's say you sue me, and here we are in court. Where are you going to go with your evidence if you're my defense attorney? What do you think? Yeah.
To the heart attack?
Okay, why? Tell me why you would go there.
Well, because you didn't have control over your body.
Right. Now, might you save them the trouble and go ahead and admit those two?
Yeah.
Sure, Your Honor. It was so unfortunate what happened. My client did, in fact, end up in her lap and break her nose. And we are very sorry about that. But Your Honor, it was not a malicious act. She did not mean to do that. And therefore, you cannot convict her of battery because she does not meet all of the criteria. So this is how you want to do some very critical thinking, both individually and in your groups. What is the law at issue? What bells do we have to ring if we're the prosecution? Or, if you're on the defense, what elements of the crime can you show were not met? So going to court and being convicted of something, it's not like going to school where there's like an A, a B, a C, a D. There's no gradations. You are in or you are out. Either you meet all of the elements or no dice. So really, all you have to do as a defense attorney is disprove one of them. Even if they've got a home run on the other ones, they got to show them all. And you want to make sure and point out to the trier of fact and the trier of law, which I'll address that in just a moment, that they did not ring every bell. Let's real quick talk about trier of law, trier of fact. In some cases, the judge does all of those things. Sometimes there's not a jury. So that is not the case in your mock trial, but since we're exploring the American justice system, I thought I'd throw that out there. When there is a judge and a jury, they are both involved in different ways. So you can think about the judge as kind of being the referee or the umpire of the situation. He or she is going to make sure we proceed in the right order, that evidence is submitted in a proper fashion. Later, they may answer questions for the jury. But if you have a jury, they are likely the trier of fact, which I'll explain more in just a moment. And in some instances, they might be making a decision on law. So the way they would make a decision on law would be something like this. Did you meet all of the elements of the crime? Because they get like a jury sheet that has the elements of crime on it. They take it back to their room to discuss, and they decide if in fact they heard facts to go with all of those things. So if the jury is part of deciding the outcome in the case, how much attention do we need to give to the jury?
99%.
A whole lot. That's right. So there are, in most cases, sometimes 6, sometimes 12, but there are multiple members of the jury. So we need to think about that when we are creating our strategy for presentation. So one of the things we do not want to do is go up there and wing it. It won't work out. And none of you look like the winging type, so I'm not actually worried about that. But here's what can be of concern. If it's like almost planned, but we haven't like played out all the scenarios. So when you're thinking through your strategy, you don't want to have an almost plan. You want to have a full plan. So we're going to start with getting organized. So you'll organize individually, and then you'll have a team. So those are different elements of organization. You'll figure out who's going to say what. But once you know your own part, you need to organize what you are going to say. So this is the part where we move into public speaking skills, that regardless of whether you want to be an attorney or not, you need to know how to be able to stand up in front of an audience and give your point of view in a very persuasive way. So let's think about situations outside of the courtroom where you might need to get in front of an audience and persuade them to your way of seeing a situation. Yes. Politically, yeah. Tell me more about that.
You could have somebody as a friend who is old enough to vote that they don't know, or are like persuaded on one side that you disagree with, and they don't even know what is behind the scenes.
Yeah.
So you want to persuade them onto your side to vote for who you think is politically correct.
Yeah. So the example is you may want to be a political advocate for a particular point of view, or a do pass or do not pass a particular law. Taxes are so fun. When you guys start paying taxes, you're going to love it. And you're going to want to really pay attention to those things on the ballot because they matter. Okay, what else? What other reasons would we want to be persuasive in our actual real life?
Persuade people to Christ.
I love this. You guys have such mature answers. I was thinking of get a puppy dog. But yes, the answer is you may want to present your faith to someone who's on the edge of making the biggest life decision that there is. That's a very important one. I saw a hand over here. Yes, ma'am.
I was thinking if you own a business, most likely there's other businesses out there just like yours, but
Yeah.
you need the public to choose yours.
Absolutely. Sales, marketing, those are huge ways. You all may not get to do sales and marketing right now as much unless you have a family business. And what a great opportunity if you do have somebody in your family who has a family business. Have you ever been with a group of friends and you all are hanging out, you got a few hours, and everyone has different ideas about what you should do with the next few hours? How does it get decided? Do we all just take turns with a timer, or how do we do it? Real life situation, what do you do when you're hanging out with your friends? A couple different ideas of what might go on.
Which one's cheaper?
Okay, that's a piece of fact that comes out. Yes, ma'am. You vote. Yeah, you're so mature. I love that. That's a possibility to vote. Yes. Yeah.
Which one's more fun?
Yes, well, fun's an opinion, right? So that's where we got to get into some advocacy. So usually from the outside looking in, when I'm watching a bunch of people hang out, they all share their ideas, and the more persuasive speaker wins. That's what the group is going to do. And that skill continues for the rest of your life. Usually, the most persuasive speaker in any group determines the outcome of what happens in that group. So, isn't it an advantage to be a more persuasive speaker and know how to bring your ideas forward in a way that other people want to join what you are presenting? Life skills. Okay, so one of the ways you want to be a persuasive speaker is you want to be organized so that you can be present. So what would I mean by be organized so you can be present? You want to do your thinking and your planning way before you get to the interactive situation. So for you all, the interactive situation for mock trial is the courtroom. But in life, it's different things. Maybe you are pitching your boss on why you should get a promotion, and you're going to prepare all these things to remind them of what you have contributed. But you want to organize ahead of time so you can be present and you can interact with the people around you. So let's pretend that this lovely front row is my jury at the trial. I need 1, 2, 3, 4, 5, 6, 7, 8. This jury has 8 members. I need 8 votes. I'm going to do a presentation in a couple different ways. You tell me how many votes you think I'm going to get each time, okay? Ladies and gentlemen of the jury, welcome to our presentation today. I would like for you to see my point of view, and I would like for you to vote not guilty. How many of the 8 did I make eye contact with?
Not very many.
0, big fat 0. So, how do I know if, what is your name in the teal shirt? How do I know if Chris was even listening? What I said? I have no idea. Okay, well, I gotta take your word for it, because I don't know. I couldn't see you, I couldn't look up, right? So, eye contact is huge in persuasion, and if I am worried about what I'm saying, then I can't look at Chris and Elijah and Jack, Ezra, Jake, Isaac, and Eva. Eva's my daughter. So if I'm worried about what I'm going to say, I cannot be interacting with them to find out if they're with me, because their body language is going to tell me what they are thinking about my position, whether I'm the prosecution or I'm the defense. So I want to be able to interact with them. And I also want to be able to play to their experience of the facts. So one of the ways you can be very persuasive is to use more than your voice. So you have a lot of tools available for you. Let's remember what I just did, and let's think through some of the persuasive tools I used. Now, did they work? I don't know. Ask them later. But what did I do with my body in the space when I wanted Chris's attention?
Look at him.
I moved closer to him, because it is very difficult to ignore someone who's close to you. Like, the closer I get, the more uncomfortable they are. They don't know what I'm going to do next, but guess what? They're going to look at me
And
just
listen,
in case.
yeah.
So you can use your space on the floor. Now, you can't get too close to the judge. There's rules about that. But you can use your space on the floor to make sure you are interacting with the jury. Something else I did is I addressed them as individuals. I didn't treat them as a faceless group. So while you can't do the kind of interaction that I did, where you ask for a name and those sort of things, but you can get close to the jury, you can gesture to a person, you can say, think of a time that you were worried, or think of a time that you were scared, or whatever emotion you're trying to help them connect to, you can use that skill to draw them in. So drawing someone into an emotional reaction that creates a decision is what the advertising industry does all the time. Because they've studied us as people, and they've noticed that if you can make an emotional spike, positive or negative, if you make an emotional spike, you have their attention, and depending on the kind of emotion you elicit, you might get some loyalty out of that person. Something else you can do is use different modes of speech. So the anti-example that I gave was monotone. One of the things you can use when you're organizing your thoughts is using different tempos. Never underestimate the power of a pause. And you really want people to notice what you're going to say next, stop talking. But in a way that shows you are fully in control of the situation, you are comfortable with the silence, and eyes pop up. And they start noticing what you're saying. There might be a time where you may want to use differences in volume, and you may want to use the same gestures again and again when you're trying to remind them of a point. So, that is part of your organization. You want to figure out the scope of what it is that you want to share. And in my opinion, you all are welcome to find your own way. When I've observed people who are successful in public speaking, usually this is the path they take to get comfortable with what they're going to say. They do what I call longhand, write it out. If you're a typer, you type. If you're a writer, you write, and you literally write out everything you think you want to say. And then after you do that, then you go back and edit it. Is that really what I want to say? Like, oh, maybe in this third paragraph, I want to say this other thing. And you work it out until you're comfortable with your content. But once again, we do not want to read in court. So that's just the beginning. You have figured out the scope of what you're going to say. You've done some editing, you've got organized. Now you want to move that to an outline. You all are familiar with outlining, I feel like. Yes. Massive life skill. So you move everything to an outline, and then you start memorizing your key points. So you literally would be like, you're doing the dishes, and you're trying to memorize your key points. I often, in the past, when I had really, really big presentations, I might tape my key points on like my coffee cup cabinet. So every time I go get a cup of coffee, I see my key points. So you want to get down cold with your key points so that if you are nervous, which everyone gets nervous, so don't feel like, oh my goodness, I must be different. I'm actually nervous. Everyone's nervous.
Right.
That's at the mock trial. We're all nervous, even the judge. So you want to take a deep breath and go back to your key points because that will orient you. So once you have your key points memorized, then you can start adding in some memorization of some subpoints. And we're still just getting started. So after you have your outline and your subpoints, that's where most people stop. But here's a really interesting fact. The dialogue that you have with yourself in your head is not the same way words can come out of your mouth. They are not super related. Have you ever noticed where you can be like super clear on what you want to say and you've practiced it in your head, and then you walk up to the interaction and you're ready to give your point and you're like, I don't know. And you stumble all over your words because they've never come out of your mouth. You have to say the words out loud to someone. I mean, your cat, maybe, dog, mirror, bedroom, and then the most difficult audience in the entire world is your own family. Honestly, it's easier to get on a microphone in a really big stadium than it is to do a presentation to your own family. But again and again and again, you want to say your words out loud, and then when you're comfortable doing that, that's when you add your gestures, or you start thinking about where you're going to move on the floor. So after you've done this a lot of times, so now I functionally get paid to do this process, where I think through what I'm going to say, I think about the audience that I'm going to be delivering it to. Mine is very interactive, so I have to think about what are they going to say after I say this thing. You do your key points, you practice it out loud, but now for me, that entire process can take less than 30 minutes. Because it's just like riding a bike or something else that you don't even think about anymore. But this first time you do it, or maybe it's the third or fourth, I think you all have done some stage presentations, it is a little tedious and it's kind of long form, but that's okay because we're learning. But you don't want to skip any of the steps, because guess when we're going to find out if you skip any of the preparation steps? In the courtroom. You can't fake preparation. You can fake a lot of things, but you cannot fake preparation. So please, my friends, be prepared by going through these processes. So the last thing you want to do when you're really comfortable with what you're going to say, you have it organized, you have your key points memorized, then you want to practice it in the mirror or practice it on film so you can see what you look like. Because sometimes we come across different than we're trying to come across. So when we're in the courtroom and the judge is watching, the jury is watching, you've got folks out there who are observing what's happening, how do we want to come across? Let's talk about the attorneys first. Let's say you're playing the role of an attorney. How do we want an attorney to come across in a courtroom setting?
Depends on which one you are.
Huh?
I said it depends on which one you are.
Yeah, tell me more.
Well, if you're trying to defend somebody, you want to make them have doubt. Or if you're the prosecutor, you want to be confident. I know this.
Confidence, creating doubt. Other ideas? Yes. Yes, you want to be prepared. Why do you want to be prepared? Good point. Because it increases your trustworthiness.
Yes.
If you
You don't look
appear calm
Yeah.
and you are not like, flipping through your papers and whispering to your friend, like, where's the exhibit? Then you look like you are prepared and you are trustworthy. Because although we do have to ring all the bells of any particular crime, or unring them, as the case would be, if you're the defense, one thing you really want to be is trustworthy. Because when they go back into the jury room, where the judge is by herself or by himself thinking through the things, and there's kind of a gray line, to maybe go this way, to maybe go that way, who's going to get the benefit of the doubt?
Right.
The attorney or the team that seemed most trustworthy, honorable, and in control of their evidence. So that's another thing you want to play through as a team. Are we prepared as a team to look trustworthy, organized, and ready to go? And you can't cheat that process. You have to actually do it. Now, the final thing that I suggest you add to your preparation is make sure you have fun. This actually can be a really, really fun process. If you allow yourself to be prepared and ready, it's awesome to be in game time and you are listening to the other side, and you should kind of have a cheat sheet. You should know how they're doing. You should know if they've hit the elements of all the laws, and if they have or they haven't, depending on which hat you're wearing. You want to be able to notice in real time and be able to bolster your argument to become even stronger in the area where they are weak. And so if you've done your preparation and you know the evidence, you are able to do that in real time.
Kind of like thinking on your feet, because
Yeah.
some of the stuff they're going to come up with might be like, crap, I was going to say this next, but
Right.
they didn't follow the script.
Right, they won't. That's a
Yeah.
good point. I'm glad you said that. Something will surprise you. And every time you do mock trial against a team that you've not practiced with, they will maybe present evidence in a different order than you're used to seeing. Maybe their witness will say something that you didn't expect. Something else you need to prepare for is, what if the witness answers incorrectly? What do you do then? Like they get it wrong. What
I
do
mean,
you
like according to the witness statement?
Yeah.
Re-ask them maybe, or make them look untrustworthy.
Am I understanding you correctly? Did you just state da-da-da? And you might have to pull some evidence in that you weren't expecting to have to pull in order to correct that. But that's something you need to prepare for, because that happens in real life. And in most mock trials that I've participated in, somebody on the witness stand makes some adjustments, usually unintentionally. They're just nervous.
Yeah.
But
That's what I was going to say. If they're on your side,
Yeah.
you want them to know
Help them
that,
out.
oh,
Yeah.
they're nervous. They need
yeah,
some.
yeah. But you need to be prepared to be the captain of that situation if you are doing either examination or cross-examination. The last thing I will leave you with, remembering, is that you need every vote on the jury. And you need the judge to follow this. This is what the judge cares about the most. But you need the jury to be on your side. And so you want to make sure that you're having interactions with the jury. Don't only speak to the judge. Make sure you use your persuasive skills on the jury as well. So I think that brings me to the end of my time. Be a lawyer when you grow up.
Hi, guys feel like your minds are exploding with lots of information right now? A little bit, right? This is really, really good. So we have one more speaker for you, and this is David Mercer. He actually used to be a prosecuting and defense attorney and just got elected to a position of judge. Was that? Selected. Okay, selected to the position of judge. Was it 2 years ago?
About a year and a half.
About a year and a half. So we're really excited that he can be with us. He's going to be able to give us some really, really good strategy and courtroom proceedings. So let's welcome David.
All right, so I'm going to do something that my wife tells me that you should never do, and that is look at your phone while you're talking to people. So, what I have on here are the topics that I was told that we should talk about. So I'm not like texting with people or playing, games or anything like that. So the last place you want to be when you're a speaker is you don't want to be the last person in the whole day because everybody's pretty tapped at that point. So we'll just do the best we can. All right. So I am a Springfield Municipal Court judge. So I do cases involving municipal court ordinance violations. Prior to that, I was with the Federal Public Defender's Office for 24 years and did criminal defense in federal court. So understand that you guys have a criminal case that you're working on. Some of you are prosecutors, some of you are defense attorneys, some of you are witnesses, right? And I also understand that you're wrestling with this question of where do we even start? Is that a fair thing?
Right.
Okay. Well, let me see if I can help you with that. So let's suppose for a minute that you were going to go make brownies. Would you have a list of ingredients? Mm-hmm. Okay. So what you have to do as lawyers, and especially prosecutors, is you have to gather the necessary ingredients to make what you're aiming for. So if I told you that I was going to make brownies and I said, I'm going to put in cottage cheese and asparagus and salmon, what would you say to me? You'd say, well, I'm not sure what you're cooking, but it's not brownies. Okay? So the starting place for prosecutors especially, but for defense lawyers too, are what are called the elements of the offense charged. Those are the ingredients of what you as prosecutors are aiming at. Okay? Every crime has a very specific set of elements. Those are the ingredients that go into the recipe of, say, for example, third-degree murder, which I understand is the offense that you guys are dealing with, right? So when I talk to students in your situation and you're asking the question, where do we even start? Start always with the elements. What do we have to prove? If we're going to end up proving third-degree murder, what are the facts that we must prove to be true in order to be successful in prosecuting this offense? And those elements, they are like the guiding stars for everything you're going to do. Because everything that you're doing should be in an effort for prosecutors to prove those elements, and if you're a defense lawyer, to disprove those elements. Now, one thing that you have as the defendants to your advantage is the presumption of innocence. So a defendant, constitutionally, is presumed to be innocent of the charged offense until something happens. And what's that thing that happens? The prosecutor proves their case beyond a reasonable doubt to the satisfaction of all jurors. There's usually 12 jurors, and in a criminal case, you prosecutors, you have to prove your case using the highest standard of proof beyond a reasonable doubt, and what you're proving are the elements of the charged offense. And the elements, let me say it in a different way. The elements are the facts that you must prove to be true to prove the defendant is guilty of the charged offense. So again, let's go back to that recipe analogy. If you want to know, prosecutors, what you have to prove to win your case, you go look at the elements of third-degree murder in your jurisdiction. I think it's Pennsylvania, right? Mm-hmm. Okay? So you got to look at the statute under Pennsylvania law that says, here's what must be true to prove third-degree murder. Those elements, again, those are your guiding stars. Every effort you make, every question you ask, every witness you call, every piece of evidence that you put before a judge or jury should be designed to prove one of those elements. Does that give you a starting point?
Yes.
Okay, and listen, I understand. I mean, I was a lawyer for a long time, and sometimes it's very overwhelming. You're like, I got this massive facts and all these laws and definitions, and where do I even start? Well, just keep it really simple. Always go to the statute that defines third-degree murder and read that and say, what do I have to prove? What are the things I have to prove to meet this definition? And then every time you go about drafting a question for a witness or looking at exhibits or whatever else you guys have, ask yourself this question: will this witness or will this exhibit help me prove one of the facts I have to prove? Okay, now let's change hats for a second. Who here is the defense lawyer? Okay, defense lawyers, you start off with innocence. Okay, the Constitution says your client is presumed to be not guilty. Okay, so how do you guide your preparation? Well, you ask yourself essentially the same question: what do the prosecutors have to prove, and how can I show that those facts do not exist beyond a reasonable doubt? Is this making sense so far?
Yeah.
Okay, now prosecutors, you have a tougher duty because you have what's called the burden of proof. All right, so think about it this way: the defendant is presumed innocent. What will change that? What will change that, prosecutors, is you carrying the burden of proof that the law places on your back. Okay? And it's very interesting. Don't write this down, but I'll tell you something that is really helpful to understand this. Have you gotten to the point where you have figured out who goes first in putting on evidence? The prosecution goes first. Why? Because they have the burden of proof. If we start with no evidence, if we start with nothing, the Constitution says that person's innocent. So prosecutors, you go first, because unless you present sufficient evidence, that presumption of innocence is going to carry the day, and that defendant should be found not guilty by the virtue of the law. Now, guess what, prosecutors? You also get to go last. Why? Because you have the burden of proof. All right? Defense lawyers, you go in the middle. And guess what? This repetition carries all the way through the system. When you come to closing arguments, who stands up and gives the first part of closing arguments? The prosecution. Who gets the last word in closing arguments? The prosecution. Why? Because you have the burden of proof. Okay? So if you are a prosecutor, you have to say to yourselves, unless we do our job, unless we prove every element beyond a reasonable doubt to the satisfaction of the judge or all jurors, if we don't do that job, we must lose. The law mandates it. Okay? So what would happen, and I don't know exactly how this exercise works with you guys, but if, like in federal court, when a jury goes to deliberate, guess what they take with them? They take a list of the statutory elements of the charged offense. They are looking at the recipe that you prosecutors are looking at. And the jurors, when they go back to deliberate, they're saying, did the prosecutor prove beyond a reasonable doubt every element that is required, that is found in the definition of this offense? And if the answer to that is no, you lose, period. It's not 3 out of 4, it's not the majority of the elements. You prosecutors have to prove every single element beyond a reasonable doubt. Now, while we're talking about that, the standard of proof in a criminal case is what I've been harping on. It is beyond a reasonable doubt. That's the highest standard that our legal system requires. Let me ask you this. Why such a high standard of proof? Yeah.
Because it affects that person, the defendant's entire life.
Because their liberty and sometimes their lives are at stake.
Right.
Okay? Okay, so before I joined the Federal Defender's Office, I represented someone who was charged with a triple homicide, and they were facing the death penalty. You better believe that I was going to make sure that the prosecutor lived up to the standard of proof, because my client's life was literally on the line. Okay? So in the United States of America, one of the hallmarks of our system that makes our system one of the greatest it's ever been, if not the greatest it's ever been, is that we require the government to do its job. And if you are a prosecutor, you are the government. And your job is to prove those elements beyond reasonable doubt. If you look at your materials, when you look at the charging document, it's going to say, I believe, State of Pennsylvania versus defendant, whatever his name is, right? Mm-hmm. Okay, so you prosecutors have this awesome responsibility. You represent all the people of the state of Pennsylvania. You are the government. Defense lawyers, you represent one person, and that is the defendant. Okay? This is huge. Maybe the most important thing I'll say all day. Justice is a process. You might want to write that down. Justice is a process. No one person, with the exception of Jesus Christ, no one person has the right to speak for justice. It is a process. It involves multiple people. It involves prosecutors. It involves defense lawyers. it involves judges and or jurors, and it involves the defendant. Those are the main players in the process of justice. The reason that our system is so great is because it does not entrust the question of justice to one person. Prosecutors, you have an awesome responsibility. And I'll tell you this, anybody here ever been to Washington, D.C.? Okay, if you ever go back there, walk to the United States Department of Justice building. It is awesome, and here's what it says on the side of the building. The government wins its case when justice is done.
Right.
Prosecutors, your job is not to win. Prosecutors, your job is not to win. It is to do justice. Defense lawyers, your job is to ethically defend your client with every molecule in your body. Okay? Witnesses, your job is to speak the truth always. Now I want you to listen very carefully to what I'm about to say because I don't want it to be taken out of context. There are two different kinds of truth. I don't mean that there are different truths, because I believe that God, in his sovereignty, is absolute truth.
Amen. Right.
Okay? No doubt about that. There is an absolute truth out there. And God knows that, and God is in charge of that truth. However, oftentimes in our human systems, like our justice system, we have to reach an agreement as to what we believe the truth is. I call it truth by consensus. And a jury, they hear all the evidence, they hear the prosecutor, they hear the defense lawyer, they read the jury instructions that have all the legal definitions and all the elements, and they have a really awesome job. We take adversaries, prosecutors, and defense lawyers, and we put between them a neutral judge and or jury, and we let them fight. There's no other way to say it. They're adversaries. You've got the prosecutor who's trying hard to prove their case. You got the defense lawyers who are trying hard to prove their defenses or to undercut the prosecutor's case. And listen, I've got some dear friends, Christian brothers in Christ, who are prosecutors. And man, when we were in the courtroom, we would go at it. Now, I'm happy to say that when the gavel ended the day, we were still best of friends. But we understood that we were part of the adversarial process, and if we don't push each other, if I don't fight zealously for my client and the prosecutor fight zealously for the government, we're not fulfilling our roles and the system is diminished.
How, like for our court case, our criminal case for third-degree murder, how would, if it was real life, how would the jury be selected? What is that process, and who gets to pick who?
Fascinating question. Okay, so the question is, where do we get juries from? Okay, so the way it works is they would bring in, they would get, and honestly, it's kind of funny you ask because my wife was supposed to be on a jury duty today, but they didn't need her. So what happens is, let's suppose that you're going to end up with 12 jurors and let's say 2 alternates. So you need 14 people to have a jury trial. Well, they're going to start with a jury panel that may be 60 people. Okay? And then there's a process depending on what part of the state you're from. If you're a hillbilly from Southwest Missouri like I am, you say voir dire. And if you're, cultured from St. Louis, you say voir dire. But that's the process of picking jurors. It comes from the French meaning to speak the truth. So I'm gonna go through this process of jury selection where I'm gonna ask, what's your name?
Michael?
I'm gonna say, Michael, have you ever been the victim of a crime?
No.
Just say yes.
Yeah.
Okay, and let's suppose that the crime was burglary and the case that he's gonna be a juror on is a burglary case. Do you think I want him? Probably not. Okay? Michael, let's say that the defendant's name is Bob Smith. Are you related to Bob Smith? Just say yes.
Yeah.
Is he your dad?
Yeah.
Do we want him on our jury? No. Okay, so we're speaking the truth about his qualifications to be fair and impartial. That's the gold standard. Is if the juror can be fair and impartial, then they will potentially be on the jury. Now, there are 2 different kinds of strikes. So with Michael, I would say to the judge, I want to strike him for cause. He cannot be fair and impartial. Okay, so all the strikes for cause have to do with this person cannot be fair and impartial, or they can't hear, or they have some reason why they can't be on the jury for this case. Those are for cause strikes. But there's another kind of strike, and that's called a peremptory strike. And that is, I'm going to strike a certain number of people. It's usually 6 to 10, depending on what jurisdiction you're in. The prosecutor gets 6 people that they can strike for no reason. I get 6 people I can strike for no reason. with one qualification on the prosecutor. They cannot strike people on the basis of their race or gender.
Right.
That's called a Batson challenge. That's where I would say, hey, judge, they're striking all the people of a certain ethnicity or a certain race. Can't do that. But other than that, I can use any of my strikes to take off people that I just don't like. And, you know, a lot of times when I was picking juries, you would have people that did not say one word through the whole process. But for whatever reason, you're just like, oh, man, I just don't know. That person seems like there's something not right with them. You can strike them for that reason. You don't have to articulate a reason why you strike them. And I'll give you one last thing that's just a really fascinating thing to me. There are people who are not necessarily lawyers, but oftentimes they're psychologists or psychiatrists. They get their entire living by being jury consultants. They sit with the defense team or the prosecutor team, and they say, this person has this particular tick, or I've looked at their review, their background, and you don't want them for this case. And they use their mental health expertise to help you pick good jurors. Now, people would say, well, that doesn't seem fair. Yes, it is fair because both sides have that opportunity.
And isn't it supposed to be a jury of their peers?
Yeah,
Or is
and
that just
that's
the
a
same
pretty
for-
loose standard.
Right.
So if I'm going to be tried by a jury of my peers, it doesn't mean that they have to be 62-year-old white males from the east side of Springfield. You're right.
Right.
You know, that is what we're ultimately aiming at, is a jury that is peers. Yeah, good question. You can do an unlimited number of strikes for cause.
Okay.
So what happens if we've got 60 people and 50 of them are related to Bob Smith? What do we do then? Well, here's what we do, is we strike the whole panel and we start another day.
Right.
And the reason, then, that's super inconvenient, but we got to get this right because somebody's liberty is at stake.
And we are from, you know, like you said, Southwest Missouri. 50 of the 60 could be related.
Yeah? Yeah, good point, good point. All right, other questions? These are good questions, yeah.
Is it always the prosecutor who gets to say this could be a lesser charge? Or does the jury decide that they could maybe plead it down
Okay,
to
yeah.
manslaughter instead of murder?
Okay, so this is actually a really cool question. Okay, so here's what her question is. You've got different levels of offenses. Like I noticed in the Pennsylvania statutes, you have first, second, and third degree murder. First degree being, you know, premeditated, deliberate murder of another human being. Well, what happens if the jury says, well, we don't think the prosecutor met the elements for first degree murder, but we think they did for third degree murder? Can they do that? And the answer is maybe. Okay? And here's how that works. And this is hard for the defense lawyer, is you have to decide whether you want to put all your eggs in one basket and say to the jury, you have to decide first degree murder or nothing.
Oh, yeah.
Or the defense can ask for what's called a lesser included offense instruction. And that gives the jury the bite at the apple, 2 bites at the apple. So as the defense lawyer, you're saying to yourself, do I want to give them 2 opportunities to find my client guilty, or do I want to put all my eggs in one basket? Now, the question also that you're asking is, can the prosecutor plead the case out to a lesser offense? And the answer is absolutely. Here's an interesting question for you. So as a federal defense lawyer, and I was there for 24 years, longer than almost all you guys were alive, except for the adults in here. If you had to guess, nationwide, how many people that are charged in federal court, how many of those people plead guilty? Percentage-wise. 30? Okay, triple it and you're getting closer.
9.
It's above 90. Keep going. About 97 to 98% of the people who are charged with federal crimes nationwide plead guilty. So let's say on a good day, 3% of them go to trial, and probably 98% of the 3% get convicted at trial. Okay? But plea bargaining is what you're talking about, and that happens in almost every case, at least in federal court, and the vast majority of cases in state court. Okay? So I don't think you guys are going to do plea bargaining, but that's just kind of an interesting side note. Okay? All right, so let's get back to helping you guys get ready for this project. Prosecutors, you should make a list of the elements of this offense, write it down on a piece of paper, and sleep with it under your pillow. Because that is everything that your life is going to be about in this case, is proving those elements. Defense lawyers, you should be asking yourself 2 things. And as a defense lawyer, you've got 2 choices to make, and I think only the second one applies here. But sometimes defendants have what are called affirmative defenses. For example, self-defense. Okay, so if I'm going to try a case, as a defendant, I can assert a defense called self-defense. And guess what? It has elements. And guess who has the burden of proving self-defense? The defendant. Okay, so there's a certain list of affirmative defenses that if you're the defense side, you got to say, do any of these defenses apply? So there's self-defense, defense of others, defense of property, alibi, mental health defenses. All of those are affirmative defenses that the defense side has to prove, and they all have elements just like the charge defense. Okay? I don't think that applies to you. So the next thing, defense lawyers, is putting the prosecutor to its proof. Okay? So you, as defense lawyers, if you're not going to assert an affirmative defense, the next thing you got to ask is, how do I defeat the prosecutor's effort to prove their case beyond a reasonable doubt? Okay? And I don't want to say that practicing law is a game, because that diminishes how important it is. But it does have strategy. It does have really hard decisions that each of the lawyers have to make. And when I was with the Federal Defender's Office, one of the things that I would do oftentimes when I had a case or a trial is I would gather up all the lawyers and all the investigators in my office, and I'd say, all right, I got some tough choices to make. Help me make these choices. Because I'm not smart enough to do it by myself. I want to have other really smart, experienced people help me with that process. And there are questions that you don't want to get into, and witnesses you don't want to call, and defenses you don't want to assert. And there's, you got to make strategic choices as a defense lawyer. Okay, and as a prosecutor for that matter. Okay, other questions? We're doing good. Yes.
How does an attorney work on several cases? I mean, because we've been consumed with this one, and I think, but they wouldn't make any money if they weren't working on multiple at the same time.
Yeah.
How do you not just get ate up?
Well, okay, so when I was with the Federal Defender's Office, I would usually have somewhere between 35 and 50 cases open at one time.
Yeah.
And that's actually a low number. State public defenders in some systems have 300 or 400 felony cases going at one time. And here's how you do that. These cases are not all at the same place at the same time. It's like if you imagine this big assembly line coming through our auditorium here, and the cases that are just starting the assembly line, those people are just appearing, having been arrested today. So I would get calls from the magistrate judge, hey, we just arrested Bob Smith on a bank robbery case, come on over. Well, Bob Smith's at the beginning of the assembly line, but Ted Turner over here, he's set for jury trial next week, and so I'm preparing his jury trial, and then there's people all in between those 2 points. Okay, so the answer to your question is, how do you keep all the balls in the air at one time? It's very difficult, but you also are not dealing with people who are all at the same critical moment in their case at the same time. Yes?
Said earlier that it can cause people a lot of pain to be accused of something, but as the prosecution is proving that you're the good guys something you should go out of your way to do?
No. No, because you're not the good guys. And I want you to hear what I'm saying. Your job is to prove your case beyond a reasonable doubt. The defense lawyer is designed to put you to that test to assert every constitutional defense possible. And I would say that prosecution and defense, they are both on the side of good. And why? Because they're part of a good process. Okay? Now, if you were to ask some of my friends who are prosecutors if they think they're the good guys, they would say, oh yeah, we wear the white hats. In fact, I go to church with somebody who I will not name, who was a former prosecutor, and they said, I liked it because I got to wear the white hat. And I'm like, well, what does that make me? It makes me wear the black hat. I'm an evil person because I stand up for the Constitution. I'm going to tell you a story. About 4 years ago, I got to go to D.C. and go to the National Archives. Anybody been there? Okay. Well, if you get the chance to go, it's pretty close to the Justice Department, so swing by there on your way to the National Archives. But you can go in and look at the Bill of Rights, which I'm so stupid, I thought that it was going to be like on an 8.5 by 11 piece of notebook paper. It's not. It's on this huge piece of vellum. And when I got to the amendment, the Sixth Amendment that has to do with the right to counsel, I got really emotional because I realized that our founders, who I believe had a divine vision of justice, believed it to be so critically important that everybody have the right to counsel that they preserved it for eternity in the Bill of Rights. And that's a high calling. To stand Okay, now I'm going to preach at you. So just get ready. The word for the Holy Spirit, anybody know the word for the Holy Spirit in Greek? It's the paraclete. It's the one who stands beside. You know what that comes from? It comes from court proceedings where one stands beside the accused. In fact, we are told that Jesus himself is advocating before the throne on behalf of us. He is our defense attorney. Now, listen, I'm not saying I'm Jesus. Ask my wife and she'll tell you that for no doubt. But what I'm saying is, and what's the gentleman's name that asked the question? Jeremiah, you asked such a great question. Because, and I want you to walk away from this and realize that if you're prosecutors or defense lawyers, you're both engaged in the process and pursuit of good. And, you know, if Jeremiah feels called, let's say he becomes a lawyer, and God calls him to be a prosecutor, man, go after that. Because that is a super high calling. And if God raises you up to be a defense lawyer, go after that and be the best one you can be. All to the glory of God. And that's good. I'm just going to tell you a really quick story. Well, I want to tell you why I became a defense lawyer. I want you to hear this from me. Back in 1994, I joined a Christian relief and development organization called Food for the Hungry. Okay? And I'd already gone to law school. I'd already clerked for a judge in Kansas City for 3 years. And I got a chance to work with Food for the Hungry. So I spent about 4 months in Bolivia. Then I came back to the United States for a conference. And while I was here in Springfield, my dad passed away unexpectedly. And so while I was helping my mom, who lives about an eighth of a mile over here, by the way, while I was helping my mom get her feet under her and get things back in order, the Rwandan Civil War happened. And if you don't know anything about the Rwandan Civil War, you should find out about it because it was horrific. Okay? And so Food for the Hungry said, you're not going back to Bolivia, you're going to Rwanda. Okay? And in Rwanda, there were two tribes that had been at war for centuries, the Hutus and the Tutsis. And they hated each other. And there came a point in their relationship where war erupted, and they committed terrible genocide against each other. Terrible. And I went to Kigali, Rwanda, walked around there, and it looks just like Springfield. High-rises, schools, doctor's offices, very modern society. Every place I went, you could see empty shell casings on the ground and bunkers in front of people's houses. I went to schools where there was terrible atrocities committed, and then I ended up in a place called Goma, Zaire, which was right across the border from Rwanda, where millions of Rwandan refugees fled the genocide, and they went to this place called Goma, and they went to a place called Camp Magunga, where I went, and there were 250,000 people dying and starving on a big slab of volcanic rock. 250,000, more than this population of Springfield. And you could go into Camp Magunga, and you could do a 360, and every place that you looked to the horizon were human beings, shoulder to shoulder, who were dying on this big volcanic rock. And in fact, the volcano was the most active volcano in the world at that time, and at night it was just an orange glow above that mountain. Okay? And in that place, in Camp Magunga, I was so overwhelmed by the human suffering and need that I was just like, cried out to God, and I was, I can't fix this. I can't fix this. And then very clearly, God showed me that no, you cannot fix this, but you can sure do something. You can't fix everything, but you can do something. And I don't know what God has made you to do or what he's going to call you to be, but I can guarantee you this, it matters.
Right, amen.
And God's got a plan for your life that is eternally valuable. It may not be being a lawyer. That's okay. I'm not here to convince anybody to be a lawyer, okay? But I am here to convince you that you should be actively seeking God's will for your life, because that is the best thing that you could ever do for yourself. And so in Camp Magunga, I just said, God, I see so much injustice. I see so much suffering. Show me how to serve justice. I came back and I became a defense lawyer. Could you serve justice as a prosecutor? 100% absolutely. Could you serve justice as a law enforcement officer? Absolutely. So I want you to see that this process, this adversarial system, is a very valuable thing that I believe has divine origins, that is a high calling, and I would just say, put your heart into this exercise, get what you can from it. Maybe what you'll learn is you don't want to be a lawyer. That's okay. All right, so I preached at you. Now let's go back to asking questions about your assignment. Yes?
As a defense attorney, have you, like, when you know someone is guilty, How do you bring yourself to defend that person?
Okay, great question. Do you guys hear her question? Okay, well, 98% of the time, I know my client's guilty. Okay, so I have really two main jobs. One is make sure that their arrest and prosecution fulfills every requirement our Constitution has. Okay, so for example, sometimes I would have clients who got arrested, and I believe that their evidence was seized in violation of the Fourth Amendment. Okay, and so we would file what's called a motion to suppress evidence, and we would litigate that to see if the gun, for example, would be excluded from evidence. It's called the exclusionary rule. So there's a whole host of constitutional questions that I ask and would fight for on behalf of my clients. The second half of the story is, the second half of representing someone who is very likely guilty is telling their story. And one thing that I would want you to know as a lawyer is I represented not defendants, I represented human beings.
Right.
And human beings are different. Okay? And so everybody's background, and I would guess that most of you guys, or if not all of you guys, come from very loving, solid houses. And you should have a great deal of empathy and sympathy for people who do not have that. Because it's awful and scarring. And so a lot of times I would represent people and they would tell me about their upbringings, and I'm just like, man, I feel so selfish. I had two parents that loved each other. I had, a family that was stable, and they supported me, and they encouraged me, and they prayed for me, and they showed me the things of God. I feel almost embarrassed sometimes to have that when I had clients who were, neither parent was there. They were both in prison because they were drug users, and they were abused, and they had nothing, and they had to just fend for themselves. And, you got to realize everybody's a human being, and they have their own story. So I don't think everybody's built by God to be a defense lawyer.
Right.
You're just not. Some people are. I'm one of them. And I like the ability to help people and to fight for justice and fight constitutionally, and I also like to tell their stories. But, I've spoken to probably 10,000 students in my life. Your question is one that everybody asks. How do you represent people that you know that are guilty? Yeah, it's a good question. I hope that answered it. Yeah. All right, other questions? Yes?
As a defense attorney, are you allowed to lie to defend your client?
Absolutely not. And I'm glad you asked that question. Defense lawyers are bound by the same code of ethics as all lawyers. And I'll tell you one thing that I was very intentional about in my practice of law is I never, ever, ever in a million years did I say something that I wasn't absolutely sure was true.
Right.
Because you can never unring that bell.
Right.
And this is true no matter what you do. You get one chance to hold your reputation, and if you lie or cheat, done. And so, I had clients who oftentimes maybe wanted me to do something that I knew was wrong, and I just had to say, I'm not doing it. Not going to happen. And, that's why winning is the last thing you should worry about. Doing justice is job one. Okay? Yes, ma'am.
These students are going to be on little teams.
Okay.
Defense team, prosecuting team. What kind of things would you say would help strengthen those little units?
Okay. Yeah. Okay, very good. When you're part of a team, it calls upon you to do something that is very Christ-like. That's be humble. You know what? My dad was a very smart and wise man, and one of the greatest things he ever taught me was everybody has something to teach you if you'll just listen. So when you're on your teams, you need to realize that everybody on your team has an ability to provide a unique contribution to the outcome. And you need to be humble and listen to them. You need to encourage and facilitate teamwork. And the way you do that, and listen, I'm not a lawyer for no reason. I'm a pretty strong personality. I tend to think I'm right, and I want you to affirm that I'm right. Okay? But I've really had to put that in my back pocket and say, okay, knock it off. You need to listen to people. You need to let them teach you and share with you. And then when you finally do that, you realize, wow, people have so much to contribute to you if you'll just humble yourself and listen. So in your teams, you should intentionally say, how do we incorporate everybody's input? How do we give everybody a meaningful role? And how do we share in the workload equally? Okay? Because sometimes, I don't know if you know these people, I bet you do. And they're like, hey man, it's just easier to do it myself. I'll just do it myself, and I don't need to, that way I can control everything. Well, get over it. You're not in control of everything, and that's a pretty unhealthy habit, and I can tell you that from first-hand experience. If you try to be in control of everything, you're really not, okay? Anybody here ever shop at Harder House? Okay, God shows me funny things sometimes. They used to have this shopping cart at Harder House that looked like a race car, and the little kid would sit in front and steer, and the parents the whole while were steering the shopping cart, and God said, okay, do you see what's happening here? You think, David, that you're steering, and God, I'm steering the shopping cart.
Yeah.
Okay? So get over it. You don't need to control everything. Let other people contribute, and one of the greatest things that you can ever do is be a part of a team that does something meaningful. That's one of the biggest blessings that life has to offer. And you know, Christ himself called 12 people to share his ministry. There's meaning in that. Yeah. And we had people like Peter who wanted to be in charge of everything. But he wasn't, and he finally had to learn some hard lessons. Good questions. What else?
If an attorney does get caught lying, is that an offense that disbars them?
Well, maybe. Depends on how big of a lie it is.
Oh.
So there's different levels of punishment in the Missouri Bar Association, and I don't know this from personal experience, but you can be admonished, you can be suspended, you can be put on probation, you can be disbarred. Law school is 3 years of your life, and then you have to take the bar exam. You don't want to lose that ticket on being stupid. Okay? You had a question, sir?
So the defendant, Tatum Zilius, has a rough past. He never met his father and his mother was homeless. Is that a good thing, that fact, is that a good thing for the defense to harp on?
Okay, that's a great question. That, in my opinion, those would be excellent sentencing factors, but they would not be relevant to guilt or innocence. So while we're there, that was a great question. Have you guys talked about what evidence is relevant versus not relevant?
Sort of.
Okay, let's go over it. So let's talk about, and you might want to write this down. So there is two kinds of there's two tests for relevancy. Okay, the first one is called logical relevance. And here's all that is. And by the way, if I haven't said this yet, I had a good friend in law school who said the law is just common sense made extremely difficult.
Right.
That's the best definition of the law I've ever heard. Okay? So there's logical relevance, which is, does this piece of evidence make a fact more or less likely? And when I say a fact, what I mean is an element. Does this witness or does this piece of evidence make an element more or less likely? If it does, then it's logically relevant. Okay, but there's a second level of relevance called legal relevance. And that is there something about this particular piece of evidence that would be unfair to introduce? Would it cause prejudice to the defendant? Okay? Most of the time, you're going to be dealing with the question of logical relevance. Does this witness or piece of evidence make an element in the case more or less likely? So, prosecutors and defense lawyers, listen to me. You already know that you're going to sleep with the elements under your pillow because you want to have those drilled into your brain because everything you do revolves around those. Okay? Every witness, every piece of evidence that you're going to produce for the court should make an element more or less likely. Every question that you ask a witness should make an element more or less likely. Okay? Because some things are so far out of bounds that they just don't have anything to do with what we're trying to prove or disprove. Okay? Good question.
How do you know how much circumstantial evidence that you can present?
Okay, let me ask you this question. What do you mean by circumstantial evidence?
If it walks like a duck and it talks like a duck and it swims like a duck, it's probably a duck.
You know, it's interesting. In federal court, have you guys talked about the difference between direct evidence and circumstantial evidence? Well, in federal court, they completely did away with that. There's just evidence. Okay? And so, basically, I wouldn't even worry about circumstantial evidence because there's just evidence, and it's either logically relevant or it's not logically relevant. Yeah. Okay, but, you know, circumstantial evidence generally means it's not like an eyewitness account of what happened. It's that you come into the room, or you see somebody walk out of the room, and they have whipped cream on their face, and you walk in and you see a pie that has a bite out of it. Did you see them bite the pie? No. But could you say circumstantially, I believe that there's evidence that they took a bite out of the pie? That's what circumstantial evidence is. Don't worry about it. It's all evidence. And would the fact that a witness saw someone with whipped cream on their face, would that tend to make a fact more or less likely if you're trying to prove that somebody took a bite out of the pie? Yes. So it's logically relevant. Okay? But the simplest thing that you guys can do, the thing that will make your lives oh so much better, as both defense and prosecutors, is just know what you have to prove. If you can just live, eat, breathe that, you're going to be way far ahead of the game. Because when you stand up in front of the judge, do you think you're going to be nervous?
Yeah.
Well, if you're not a human being, because you're going to be nervous. I mean, look, I've tried a lot of cases that were really high stakes, and man, every time I was scared to death. Okay, I was super nervous because this is a big deal, and it's very easy to get overcome with nerves and just lose and be like, I don't even know where to start. The elements are like an anchor that you can always go back to and say, well, I don't know what to do next, but I know that it better prove or disprove one of these things. Okay?
How do you necessarily deal with your nerves?
Okay. This sounds like a stupid answer, but it's really not. You just have to start.
Yeah.
So, I can tell you this, like in a jury trial, when it comes to closing arguments, and you know everything is on your back, and you're just freaking out because you're like, oh my goodness, this comes down to what I'm about to say in the next 30 minutes. Here's what I've found. When I'm walking up to the podium or I'm walking up in front of the jury, I am super nervous. But if I have a starting point, that I know that's where I'm going to start. If I can get 30 seconds into my comments, I'm in my element. I just got to get started, okay? So I'll tell you one thing that I've done in my career that's been very helpful that someone taught me in law school. I used to do a lot of what are called oral arguments to the Court of Appeals. The 8th Circuit Court of Appeals is in St. Louis, and you'd go up and you'd argue cases in front of them, which is terrifying because there's 3 judges. They're not jury trials. They're legal arguments on appeal. And you argue to a panel of 3 judges, and while you're making your argument, they can stop you and ask you any question about the case they want to ask you. And you got to just answer it. Okay? And what I finally figured out is if I went up there and had nothing, that was terrible. But if I had 160 pages of briefs, that was terrible. Okay? So what I did, and someone taught me this, is I would take a manila folder and I would write an outline on my folder of the main points, the main cases. I'll get that. I'm just kidding you. I had this guy in court today whose phone went off. It was the loudest ringtone I had ever heard. He couldn't get it shut off, and then the next thing I knew was Ron Hurst was giving me a weather update.
Oh, yes.
So, anyway.
Good old Ron.
So, I would have an outline of what I needed to say, the most important things I needed to say. And why did I put it on a manila envelope? I'll tell you why. Because you can't drop it and get it all mixed up. If you drop it, you just pick it up, and here's a manila envelope, and it's got all your main points on it. Okay, so get started and have an outline of what you know you need to say.
So if you have a plan for a question, how will you draw it home if it wasn't answered correctly?
Did you hear his question? So what happens if you ask a question of a witness and they give you the answer that you weren't looking for? Okay, I'm really glad you asked this question because it gives me an opportunity to talk, especially to, well, I think to both sides. That's going to happen. Okay? Now, the key is don't lose your mind when it happens. Okay? And sometimes you just have to, maybe the witness is nervous too. And so you have to gently redirect them and maybe ask the question in a different way. Or if you think they're lying, you can come after them a little bit if they're lying. Okay? But a lot of times, and listen, one of the things I learned early on was jurors, they don't like it when you're mean.
Yeah.
Is there a time to be mean? Yeah. Yeah, I mean, I had a jury trial up in Jefferson City where my client was charged with threatening to kill a federal judge who was actually a friend of mine. And the main witness, the star witness for the prosecutor, was a liar. In fact, I asked him point blank, you lied to me, didn't you? Yeah, I did lie to you. Well, okay. The jury doesn't mind it if you're a little bit mean with people who are going to come into court and lie. But for the most part, witnesses are scared. They don't want to be there. Sometimes they're younger. You got to be nice to those people. So if they don't give you what you want, number one, don't be mean to them unless they deserve it. Then that's probably not going to happen in your case. And when I say be mean to them, again, it's so that the jury can hear everything and make a decision based on the evidence. But come back and ask it in a different way. And here's maybe the most important thing to answer your question. If you're just getting nowhere, move on. Okay? Because if you keep beating a dead horse, it gets ugly in a hurry. If you're not getting what you need from that witness and you've tried to maybe rephrase the question and do it in a different way, and you're not getting anywhere, just move on. Maybe get it from another witness. Maybe get it from a piece of evidence. That's where you have to be creative. Okay, what's your name?
Jack.
Jack introduced a really great topic for all of you lawyers. Have you guys talked about direct examination versus cross-examination? Okay, when do you use direct examination?
The best if it's your witness.
If it's your witness. So if you call that witness to the stand, you have to use open-ended questions, not cross-examination questions. So what's the difference? What was your name again?
Michael.
So let's say Michael's my witness, and I called him to the stand. So I would say, Michael, what color was the light when the collision happened? Just back up, one of the three colors.
Red.
Okay, it was red. Okay, I've called him, I've asked him an open-ended question that does not suggest the answer I'm looking for. If I am cross-examining Michael, here's what I'm going to say. Michael, the light was red, wasn't it?
Yeah.
Do you see the difference between those two questions? The cross-examination question is called a leading question, and it suggests the answer I'm looking for. When you call your own witnesses, you have called them to tell a story that is relevant to the elements of the case, right? When you are cross-examining a witness, you want to be in control. And here's the prime rule of cross-examination. You might want to write this down. Never ask a question on cross-examination that you do not already know the answer to. Because what you're doing, if you ask a question of a witness, and you don't, like Jack said, you got this witness on the stand and you ask them a question and you don't know the answer, 9 times out of 10 they're going to drive a truck over you. Okay? Don't ask questions that you don't know the answer to because you are in control as the cross-examiner. So you need to know your facts and the witness's testimony so well that you can use them to tell your story. And trust me, I've violated my own rule enough to know it almost always burns you. I had a client one time, this was not a criminal case, it was a mental health case, and I stupidly asked him the question, if you were released into society, would you be a danger to other people or their property? He said, yeah, I probably would be. Okay, we're done at that point. Okay, over. Because I asked a question that I wasn't in control of. So when you call witnesses, especially when you're cross-examining, try to be in control. Ask questions that are leading questions, not open-ended questions.
If you ask them a yes or no, like we practiced in class, yes or no, London did blah, 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 do they have to answer yes or no, or can they ignore you and be like, yes, but can you shut
the judge
them down?
will, you can ask the judge to direct them to answer the question yes or no, but the judge is going to let either the witness explain their answers. It's Jeremiah, right?
Oh, okay, yeah. So with the pie and the cream on the guy's face, is that, if there was no one else in the group, there was just one guy, is that enough to be beyond reasonable doubt?
That's up to the jury. So if you're saying if there's just one witness, but no one saw it happen firsthand.
Yes.
Yeah.
So, like you would leave it at that. If you had cream on the mouth, one bite of the pie, you could leave it at that.
Yeah. As a matter of fact, the very last case I tried as a defense lawyer before I joined Springfield Municipal Court was an assault case at the medical center. You guys know where the Federal Medical Center for Prisoners is? Kansas and Sunshine. And my client was charged with assaulting another inmate. The surveillance videos show the victim go into his cell. My client follows. We don't know what happened inside. My client exits. The victim leaves the cell with a swollen head and bloody face. Did anybody see what happened inside other than the two? Nope. Did the jury find him guilty beyond a reasonable doubt? Yep. Yeah, so they can. Absolutely excellent question. Yes?
This is regarding the questions on the direct and a cross. What would cause an objection for a leading question?
Okay, so if I have called you as a witness, and I say, the light was red, wasn't it? The opposing counsel would say, objection, leading. And the judge would say, rephrase your question. And I would have to say, what color was the light? Okay, so if I'm going to lead you, I'm going to suggest the answer I'm looking for. Another way of determining whether it's a leading question is, can it be answered by yes or no? If I say, what color was the light when the collision occurred? You can't answer that yes or no. You gotta pick a color. But if I say the light was red, you can answer that yes or no. Does that make sense?
It does.
It's tricky though, isn't it?
So why would you ask it
on a
ways?
cross,
if there's
Why would you ask a leading question?
Why would you ask
One answer, control.
Right.
Okay, because if I say, what color was the light? Now I'm kind of leaving it up to you to pick your answer. Whereas if I say, the light was red, wasn't it? I'm more in control of it. So in the law, if you call a witness to the stand, you have to use non-leading questions. When you cross-examine, the law permits you to use leading questions.
There's the.
So could they object?
Oh, yeah.
If you're doing cross?
Absolutely.
Even though you're supposed to be using, even though you're allowed
If
to?
you're doing a direct exam and you ask a leading question, the other lawyer should object, and that should be sustained.
But not in cross.
But not in cross?
Not in cross.
Okay.
In fact, you're crazy if you don't ask leading questions in cross, because you're just saying, hey, kick me out of the park. That's saying, would you be a danger to other people at a property if you were left? Yeah, I probably would. I mean, you're asking a question that you don't have control of. Yeah, excellent. Yes?
If the opposing side does not offer an objection, are you free to keep asking any kind of questions you want?
Yep. It depends on who your judge is. Sometimes the judges will intervene and say, that's a leading question, or that's not relevant. Not much. And so that's a really good thing. When you're listening to your witness, when you are listening to a witness being questioned and you're not the questioner, you better be on your toes, because if you don't object, that's going to come in. That's going to be permitted most of the time. And while we're putting fine points on this, here's something that most people don't realize. If a person does not object to something that's happening in a trial, for the most part, that's gone forever. Can't be reviewed on appeal, it's lost. I represented a guy along with another lawyer in a murder case, and the question on appeal was whether the defense made an appropriate, specific objection. And if we had lost that issue, we would have waived that issue, and that guy would still be in prison. So, yes.
How do you put together a closing argument?
Oh, great question. I'm so glad you asked that. Closing argument. Now, if you had to guess right or die, what I'm going to say should be the guide to your closing argument. What would you say? Starts with an E. Elements. Okay? And those elements should guide your opening statement. They should guide every question you ask, every witness you call, every piece of evidence that you want to put before the court. And they should be the center point of your closing argument. In your closing argument, you need to tell the judge or jury why, if you are the prosecutor, why you have proven every element beyond a reasonable doubt. And I mean specifically. You need to point to individual witnesses or evidence that show that you proved your case beyond a reasonable doubt. If you're a defense lawyer, you need to also use the elements and argue why the government failed to prove its case beyond a reasonable doubt. Her question was, how do you memorize? And my answer is, I don't. There are some lawyers who are way smarter than I will ever be, and they can do that. I am not one of them. I like to have an outline. I want to know what my main points are, and I want to have that available to me so I can look at it. That's a great question, though. And again, the manila folder that has the elements, that has your star witnesses and what they said that was important, you could do your closing argument from that. Yeah.
So I've witnessed some of the mock trials, and some of the judges' critiques are about missed opportunities to object. So how do we prepare them to know when it's appropriate to object?
Yeah. Well, I'll tell you something. I'll answer that. I don't know about you guys, but I can tell you this. I was raised by super nice Southern people who would never do anything to make another person upset or mad. And I had to get over it for this purpose. Now, I'm still a pretty nice person in my daily life, but when you're a lawyer, you got to be willing to interrupt people. You do. And that's sometimes the biggest hurdle is not knowing when to object, but feeling like you are empowered to object. And you have to. Okay? So now in terms of what objections you make, I'm guessing that you guys probably look at things like relevancy, hearsay. You guys talk about those things?
Yeah.
Okay. Here is my best advice to you on those. Make a list of objections that are common. Relevancy, hearsay, those kinds of things. And really understand what they mean. I mean, for the most part, lawyers object on, 90% of their objections are to relevancy and hearsay. If you really understand those things, that'll go a long way. But try to understand the other things, and then just don't be afraid. I mean, what's the worst thing that can happen if you're wrong? You get overruled. It happens, okay? I don't know about you guys. I don't really go out of my way to look stupid. It happens. But I don't try to find those situations. But, there's that saying, nothing ventured, nothing gained.
Right, take a risk.
Yeah, take a risk. If the judge says, no, I'm going to allow that testimony, okay, let it go. And, one of the things, this goes back, what was your name again?
Yeah.
This is a great point that Jack introduced to us. Don't get too fired up about being wrong. You're going to be wrong a lot in life. It's okay. Being wrong is a phenomenally good teacher. And it's okay. So just realize that especially in something as technical and detailed as the law, you're going to be wrong at times. It's okay. You'll get over it. All right. Yes?
When you're making objections, do you think it's more respectful to say your honor every single time, or just say objection and then say what the objection is?
Yes. And there's a couple of reasons for that. Her question was, do you want to say objection, your honor? Well, number one, as a judge, I'm speaking as a judge now, yeah, we want people to say your honor because we love that. And you want to keep the judge happy because happy people tend to side with you more than unhappy people. But there's another reason, and I'm not kidding around here. When you stand in front of a jury, especially, man, you need to be on your best behavior because you are part of a process that is way bigger than you are and way bigger than I am. And I always took every occasion, and this wasn't false, this was me really expressing how I feel. I want the judge to realize that I do in fact honor him or her because they are given an awesome responsibility to speak on behalf of the law.
Right.
And I want the jury to see that I respect that. Because when it comes to them deciding the case, I want them to respect the rule of law above all. Okay, so there's a lot of things that are interesting in our legal system that are meant to kind of provide a system-wide affirmation of how important what we're doing is. Like, for example, I'll tell you this. Every day, today included, there's a moment in time when I put on my robe as the judge. And I want to tell you what I do every time I do that. I pray. I say, God, please make me a good voice of justice. Please make me fair and make me able to treat people with respect. Because I have a lot of people that appear in front of me who are rough people. They're homeless, they're substance users, they're unemployed, they haven't showered in a month. I mean, it's rough. But you know what? Those people were created by God, and they deserve to be treated with the best respect I can give them. So when I put on my robe, and I'll never forget the first time I did it, I put on my robe and I kind of laughed like, are you kidding me? Like, you have any right to put on a robe? But that robe is a covering of David Mercer, and it is me speaking on behalf of our system.
Oh, yeah.
And that's an awesome thing. Okay? In our courtroom, there are flags. There's the United States flag and the Missouri flag. Those flags stand for a rule of law that is huge. The rule of law is one of the greatest gifts that has ever been created from God to human beings, and that is that we're all going to be bound by the same rules, and we're all going to be equal in the eyes of justice. In the federal courthouse, this is kind of interesting, or at least I think it is, there's a defense table and a prosecution table in the courtroom. The defense table, if you get up under it and look underneath, there's a curtain that's floor level between the jury and the defendant. If you had to guess why that is, why would you guess? Oh, that's part of it.
So
When the defendants come in the courtroom, what are they wearing, do you think? And leg cuffs. So they take the handcuffs off, but they leave the leg irons on them. So when the jury's sitting in the jury box, they can't look at the defense table and go, man, that guy's got leg irons on. He must be a bad dude.
Biased, yeah.
It's a protection of the presumption of innocence. Okay, so our system has so many checks to make sure that the right thing is done and that people are treated fairly. And, you know, that's just a huge part of our system. Anybody here ever actually gone and witnessed court before? You should go. I mean, courts are open to the public. It is fascinating. And if you ever want to come to Springfield Municipal Court, I can make that happen. So, other questions? Did you guys think of anything? Okay, so the question is there anything that I see that's wrong with our system? Yes, that's a great question. One thing that's wrong, and I can't remember who asked, I think it was one of you guys that asked about cheating. There's a lot of people who are on our system who are there to either to make $1 billion or to win. And unfortunately, a lot of times, lawyers are more concerned about that than they are about justice. And our system is not perfect. You know, so you have people that are willing to cheat and to lie and to do things that are unethical to win, and they don't always get caught. Okay. The other thing is it's very slow. There's an old saying that the wheels of justice grind slow, but they grind fine. And what that means is it takes a long time, but we usually get to the right result. You know, some of the cases I had, people were awaiting trial 2.5, 3 years. So I hope you don't ever watch television law shows because they're complete malarkey. But like, there's one, I won't name names, but I think it's called like Law and Order, where like the crime happens on a Thursday afternoon and they start the jury trial the next Monday. That never happens. It usually takes months and oftentimes years for the system to grind out the appropriate, and it's slow. Yeah, good question. Other questions? You guys are on a roll today. Yeah.
My mom says that there's a lot of like people who go to law school. There's so many people that there's not a lot of jobs.
Yeah, that kind of ebbs and flows. Her question was, do so many people become lawyers that there's no jobs for lawyers? It's like any other profession. It kind of ebbs and flows. When I went to law school, they had a hard time getting enough students to fill the class up. So the dean of the law school thought that we were just like riffraff, because they were just like, hey, we'll just take anybody. And so they took anybody, and he thought we were pretty low. But yeah, don't let that discourage you. If God calls you to be a lawyer, God's going to find a place for you to be a lawyer. Yeah, good question.
You need to wind it down.
Yep.
I don't know about you all, but I'm taking this a little bit more seriously than I was thinking last week. So if we can all think